The court decision to set free software developer Rose Njeri was facing computer misuse and cybercrimes charges for her innovation to help Kenyans reject the 2025 finance bill by sending emails directly to the Finance Committee at the National Assembly has raised public discontent over the leadership of the Office of the Director of Public Prosecutions. Lawyers are split on whether Principal Magistrate Geoffrey Onsarigo acted within the confines of his court or went out of his jurisdiction. Bridget Ngana begins our broadcast tonight.
We shall be praying that you be available with a certificate copy of the ruling.
On Friday, Milimani Principal Magistrate Geoffrey Onsarigo handed software developer Rose Njeri her freedom after she was arrested by police for setting up a website where Kenyans could oppose the 2025 finance bill by sending mass emails to the National Assembly Committee on Finance and Planning at the click of a button as part of public participation. In his ruling, Principal Magistrate Geoffrey Onsarigo refused to admit the charges leveled against Njeri by the Office of the Director of Public Prosecutions, saying they were vague and lacked a solid legal backing.
In line with the said provision of statute and the reasons that I've stated above, I hereby refuse to admit the two counts before this court, and therefore I hereby proceed to discharge the suspect, that is Rose Njeri Tunguru, under Section 895 of the Criminal Procedure Code.
According to the court, the prosecution only relied on two parts of Section 16 of the Computer Misuse and Cybercrimes Act of 2018, which says, Part 1, a person who intentionally, without authorization, does any act which causes an unauthorized interference to a computer system, program, or data commits an offense and is liable on conviction to a fine not exceeding 10 million shillings or to imprisonment for a term not exceeding 5 years or to both. Part 3, which says, a person who commits an offense under subsection 1, which results in a significant financial loss to any person, threatens national security, causes physical injury or death to any person, or threatens public health or public safety, is liable on conviction to a fine not exceeding 20 million shillings or to imprisonment for a term not exceeding 10 years or to both. And that the prosecution failed to justify how Njeri's innovation caused harm to her accusers, who in this case is the government.
Guided by the decision of the Court of Appeal and pursuant to the doctrine of stare decisis, I reached the finding that the two counts, as presently drafted, do not disclose an offense as they are ambiguous.
But some lawyers are baffled by the pronouncement of Principal Magistrate Onsarigo, saying he punched above his weight.
The import of a generic argument that because the Information Act was declared unconstitutional and the ingredients look like the Cybercrime Act was importing wrong provisions of the law to apply to a specific charge. And that is why, in my own view, I find that the learned judge overstepped in his mandate to not admit the charge.
Others say the Office of the Director of Public Prosecutions is being weaponized by politicians to silence dissent.
And this is a very clear case of abuse of the court process, to use the Office of the Director of Public Prosecution and the court system to manage politics, to try to breathe life into the finance bill of 2025, which was going to be opposed by the people that were being approached by Rose Njeri. This is not what we should be doing. The Office of the Director of Public Prosecution should go for those people who are looting in counties, who are stealing monies meant for airports.
For now, Rose Njeri remains free after the court dismissed the charges leveled against her by the Director of Public Prosecutions, who is expected on Monday to go before the High Court to seek a reversal of Principal Magistrate Geoffrey Onsarigo's decision. Bridget Ngana, NTV.